to go back to Justice Sotomayor's main point there, which is, I understand the concept of we have to give states flexibility. This is a new situation. The idea of application versus something else is kind of new, and so we're announcing it here for the first time. But I wonder whether this isn't a place where the bad faith part of it comes in. That to the extent that you would have otherwise had a presumption that you needed some time to work out your interpretation of this rule, in this very unique situation, why shouldn't we say you don't really get that presumption because your friend on the other side says 12 times the court told you what the law was and you refused to apply it?
Well, Justice Jackson, maybe it might help by putting some context into how this came about, because before 2002, before Ring, this was really a non-issue in Arizona. So even though Simmons was decided in 1994, until from 1994 to 2002, judges made these determinations.
I'm sorry, what is the this? This is, you mean whether or not you get to have this instruction?
Well, before it ever was an issue in Arizona, because judges made the determination of death and aggravators and sentencing, right? So then Ring comes out, and now Arizona now has to apply Ring. Juries are going to make the aggravator determination. So the first time that the issue came up was actually in this case itself. So this is now we're in, the crime was committed in 2003. His trial was in 2005. So the Arizona Supreme Court's trying to figure out how the Simmons claim applies here. It was not properly presented below. I just respectfully disagree.
But why doesn't that undermine your claim then? I thought you were saying ultimately that the reason why this is not a significant change is because this was the way the law always was, and so that's how our rule, why our 32G now bars him. But you're suggesting with this part of the story that Arizona wasn't really sure of what the law was before, that they can't now say, oh, it was so settled that you don't get the benefit of collateral review because they hadn't really sorted it out early on.
Yes, Your Honor, I understand the question, but I mean, the Simmons rule is clear. I mean, the holding is clear. If the future dangerousness is at issue, then the defendant can ask for a parole and eligibility instruction through either instruction or argument. What was unclear was whether parole was unavailable in Arizona, because the problem was in the criminal sentencing statutes, these are the statutes that the judges and the prosecutors and the defense counsel are looking at. It said at the time that there were three options. There was either the death penalty, there was a natural life sentence, or there was life with the possibility of release or parole after 25 years. It said that. The issue was in a separate title, Title 41, the administrative section for how parole is actually undertaken by the Arizona Board of Executive Clemency. The Arizona legislature flipped off the switch. So it's not even clear to us if anyone was necessarily even aware of that early on in the case. So, and then you have to remember in Simmons, and as I read this before, this court, very clearly said that the state law has to prohibit the defendant's release on parole. So it didn't, though. It had that.
I see. So you're not at fault. It was confusing. You didn't really know. It was possible that he wasn't getting parole, or he would get parole, and so it may not apply.
He might get it after 25 years.
All right, so forget the bad faith then. Okay. I mean, you were doing your best in all of this time.
It was definitely not bad faith. Okay. Absolutely not bad faith by the Arizona
So then
Supreme
we come now to today, and the Supreme Court this court makes very clear that in this situation, he is supposed to get it. I'm just still wondering why the rule for collateral review does not allow for that to be considered a change, a significant change from the time in which Arizona was confused about whether he gets it or not.
I understand. It's just not the way the Arizona Supreme Court approaches significance. I mean, this is the Arizona, remember, and this point was made in some of the questioning to my colleagues, that the Arizona doesn't have to allow for this PCR process to begin with, but they do in Rule 32.1G. They allow for a successive PCR to occur. And in that rare situation, and I'm quoting Justice Hurwitz's majority opinion in the Shrum case, it's got to be a rare situation where the underlying rule of law has changed. It's not going to happen very often. So it doesn't mean just because it doesn't happen very often, or it has to be the way, the context in which it's come up here, that it's somehow inadequate.
I thought we agreed there was a change. There was just not significance. So now we're saying it has to change.
Every appellate decision interpreting the statute is a change in some respect. So that it's not just whether there's a new case that maybe a defendant would have benefited from had that case been in existence at the time of his trial. That happens all the time. They finalize their direct appeal. They finalize their as of right habeas. Maybe they're even finalizing their federal habeas, but it doesn't mean that a subsequent case, just because it comes out and maybe it involved an interpretation of statute that would have benefited to the defendant, that's a significant change. That's just not how the Arizona Supreme Court approaches that rule.